on election law. The central question in Moore versus Harper is whether state legislatures can make rules regarding federal elections without the input from state courts. For more on this, I want to bring in CBS News election law expert and political contributor David Becker. He is also the founder and executive director at the Center for Election Innovation and Research. David, thank you for being with us. As a way to set the stakes for understanding this case, you spoke with Republican lawyer Ben Ginsburg Tuesday. Let's listen to what he said.
Adoption of a full-throated independent state legislature doctrine would set on its head 230 years of the way we've been doing business. And that is no small matter. Certainly will be no small matter in the trenches among election law practitioners in dealing with the issues that this really extremely radical theory would undertake.
So Ben Ginsburg, lifelong Republican, worked in the trenches of Republican law, says it's 230 years of law and no small matter. So what, to use Ginsburg's term, would a full-throated independent state legislature doctrine look like?
Yeah, Ben is exactly right, and Ben would know better than almost anyone else. We all remember as kids when we learned about the majesty of our democracy here in America, where we had three co-equal branches of government, the executive, the legislative, and the judiciary, but they had checks and balances to make sure that no one branch would predominate over the others and couldn't do whatever it wanted to. What the independent state legislature theory says is that that's not true for this one exception, for this one carve-out of election policy and redistricting, the very policy that decides who gets elected to the executive branch or the legislative branch, and that particular area wouldn't be subject to state court review or under the state constitutions that actually formed the state legislatures themselves. It's actually a rather radical theory. It's never been adopted by a majority of the court before, but the Supreme Court will be hearing it in total.
So let's imagine that the Supreme Court were to adopt this independent state legislature theory. How would this change future federal elections, and what does it mean? I mean, it essentially means putting people in charge of the elections that put them in the office in the first place.
Yeah, we already have that to some degree. Legislatures get to make laws. The executive, in most cases, can veto those laws if they don't like them. And of course, the state courts can review them, and sometimes federal courts as well. But if we remove this very important layer of review, where state courts can decide whether or not the laws that were passed by the legislature might violate the very state constitutions that created that very same legislature, if that was gone, we could see a lot of political gamesmanship, changing rules shortly before an election to try to game the system so that the political party of the majority in a state legislature had an advantage, and perhaps confusing voters, and just as importantly, perhaps breeding distrust of the system, which we're already dealing with right now because of ongoing attacks on our democracy.
I want to go back to Ben Ginsburg for a moment, in that he was fighting for the Republicans in Bush v. Gore after the 2000 election, where this idea came up a little bit in the Supreme Court jurisprudence. Can you remind us of that history? And do any of the current justices agree with that past history?
Yeah, back in 2000, it appears that three justices flirted with this idea. It wasn't relevant to the ultimate decision in the case, and it didn't appear that it had any kind of majority embracing this very, very novel and somewhat radical theory of this independent state legislature being able to do whatever it wanted to do. What we're seeing now is it appears that there might be three justices again who embrace this theory. What we don't know is where the other justices lie, and whether they think this is appropriate for state legislatures to do whatever they want without any state court review and throwing a lot of litigation into the federal court system, which, of course, the United States Supreme Court oversees, which might inflate the number of cases they might actually have to review that might actually decide elections in some cases.
And so as you're listening to arguments on Wednesday, what will you have your ears perked up for?
Well, there have been some amazing briefs in this case. There have been briefs filed by all 50 state Supreme Court justices, whether they were conservatives or liberals, opposing the independent state legislature theory. There are conservative legal minds like Stephen Calabresi and J. Michael Ludig and Ben Ginsburg who've written amicus briefs and written on this subject, who've pointed out that there's nothing in the Constitution that would suggest this carve-out was appropriate. And one of the things I'm really looking for, especially from kind of the three justices that may be in the middle here, is what kind of questions are they asking that would indicate that they share some of the same concerns being brought forward by some of these great conservative legal minds, and also are playing this out to see whether or not this would create unintended consequences. It isn't just Republicans that could take advantage of this. There are states where Democrats control the levers of government as well. And if the independent state legislature, a robust view of it, was embraced, it might lead to partisan gamesmanship on both sides.
All right, David Becker, thanks so much for being with us.